Yes, good afternoon. Good afternoon, everybody. For those who just turn up or just tune in, you will see that we had done some discussions in our chat box. And right now, we are talking about the video recordings or availability of that. I haven't checked myself, but I should think, as at least with my previous classes, all the recordings are available on Soul 2.0. I don't quite understand your question, Honman. Could you say more about that, or would you like to speak rather than type? I can turn your microphone on. Then Honman, yes. Would you like to speak? Tell me what what is that on your mind? You said, I would like to finish assignment on New Year 2021 on or before. Would you mind help me? That's what you wrote, but what was it that's on your mind? Yes? Could you say that? I mean, I've turned on your microphone, gentlemen. You alright? Right, I had tested my microphone and also tested some of your classmates' mic as well before we started. The assignment, yes, first of all, first thing first, could any one of you just acknowledge, just let me know if you could hear me. Chen Honman, can you acknowledge, or Park Sing, or can you? Yes, that's good. And presumably you can also see me, if you know what I mean. I'm sharing my ViewCam image with you. Although I had not asked it specifically, but you are most welcome to show your face. That's very good. You will see that because I have found using earpiece to me is not comfortable, so I had changed it to something else. Thank you so much. All right, just going back to the question that was raised by Jiang Honman. I've turned on your mic. Is it that you do not have your mic with you? Because you see, this is really for everybody's sake. If you're able to speak, it's much more efficient. Typing is not only that it's taking time, and secondly, it's less easy to express your ideas more clearly. In our context, I mean, we are having a lesson. We are not doing correspondence. If this was a correspondence course, then yes, I will have to accept it, and then we will have designed the course to to cater for the teaching means. But as you realize, I mean, this is a contingency measure that we are adopting because of the epidemic. So our teaching has always been, until now, face-to-face. All right. Honman, if you're not going to elaborate on your question, I shall leave it for the moment, and please raise it at the time when you thought it appropriate. So I'm disabling your mic, and just a matter of class administration. If you don't, just tell me you don't have. Have you, among yourselves, identify any class representative for easy communication with the school? Or there may not be one, there may be more than one who has been sort of appointed or regarded as your rep, as a representative. If there isn't, doesn't matter. Right, it seems that there isn't. Now, for our class, where we are now is chapter 5 of the manual, and it is this. The heading is system of government. You will see that we are focusing on more on the executive and the legislature, and we will be looking at, or the chapter that we have produced for you will focus on the meanings of executive-led government, separation of power, and checks and balances. You'll be identifying the powers of the chief executive, and in the context of that, consider if there might be any limitations, both in law and in practice. Following that of the chief executive, we will be looking at the Legislative Council, its composition and its powers under the Basic Law. And same with examining the powers of the chief executive, we will be also looking at limitations or restrictions. And then, as a separate topic, we should be looking at the elections of both of the chief executive and members of the Legislative Council. So that's what we are going to do. You see that I have put on the screen the logo, well, what normally used, the logo used by the Hong Kong Special Administrative Region Government. The other one is actually the emblem of Legislative Council. I hope you recognize them. You recognize them. And as far as the text of the Hong Kong Basic Law is concerned, we will be looking more closely at Articles 43 to 79. These are articles contained in Chapter 4 of the Basic Law, Chapter 4 entitled Political Structure. If you want to read Mr. Gidding's book, you please go to Chapter 5. Chapter 5 of Mr. Gidding's book. In terms of cases, we have listed out 4 the more important court decisions Leung Kok-hong against President of LegCo number 1, Yao Guangman, Secretary for Justice, against Secretary for Security, another Leung Kok-hong against Chief Executive, that was year 2006, and then Chen Ka-shun against Lei Feng-ying, 2011. There will be another case which will be soon decided by the Court of Final Appeal, and I think that decision should come out on Monday, 21st of December. I was told yesterday that that particular case, in which I'm one of the lawyers representing government, the case was heard by went before the Court of Final Appeal last month on 24th and 25th, and I was told that the Court of Final Appeal will be ready to hand down its judgment on Monday. So come Monday, and when we meet, I think we meet next Tuesday, we shall have that case. Let me see. Oh, we don't. When are we going to meet next? After today? That's 29th. Oh, very well. So, that is even better then. By that time, we will have the case, and then hopefully you will have read the. And I hope by then I hope you will also pick up that judgment and take a look at that. It will, I hope, discuss the relationship between the chief executive and the executive authorities and the legislative council in the area of lawmaking, and more particularly whether the emergency regulations ordinance contravene the political structure designed in the basic law. So in that case, the factual background actually relate to the anti-mask laws that were made by the government, the chief executive in EXCO, back in last October 2019, in light of the civil disturbance at that time. It was Hong Kong was at that time was having a lot of street protests, and the people wearing masks and black dress, and various crimes of arson, criminal damage, unlawful assembly, and riot were committed. Okay, so that's that case, and in terms of many students ask me or ask us how many cases do they have to learn, do they have to memorize anything. On this one, I as I always said, for information and material contained in the manual, that is the minimum. You really have to know, understand, and apply the information contained in the manual. Anything outside of the manual, you don't have to, unless I mention specifically. So this particular case, which is going to come up next Monday, we will spend a little bit of time on it, and hopefully you should know it, for the purpose of examination. And I hope it's not going to. Well, I don't know yet, but whatever it decides, I'm sure will be of relevance, of great relevance, because it is a Court of Final Appeal decision. So that's that, and let's look at the details. Chapter 4 is the longest chapter. It takes up 40% of the articles. There are 140, 160 articles, and with we have nine chapters. Chapter 4 is spanned from Article 43 up to Article 104, divided into 6 sections. Now, although the order that these sections are arranged on their own, that on that particular order, it seemed to already give you an impression of the hierarchy. The hierarchy: who is more senior, who is more important. They come first, and that is the chief executive. And in terms of provisions, they are mainly 43 to 58. Come Article 59 to 65, only 6 articles, and they cover executive authorities. Executive authorities is the translation used for the Chinese expression of 政府, 政府. The normal translation, the usual, more common translation in Hong Kong of 政府 is government. And indeed, in the day-to-day description of the executive authorities, the English word government is more commonly used. However, in the body, in the provisions of the Basic Law, executive authorities was chosen as the English translation. And you will see that simply from the literary point of view, from the language point of view, the expression executive authority was given a functional meaning. When you read Article 59, you will see this. You will see how it's expressed, and I hope you understand what I mean. It says, the government of Hong Kong Special Administrative Region shall be the executive authorities of the region. And executive authorities here is spelled in the lowercase. It's not a proper noun. It's not the name. The proper noun, the name is government. The government. And it says shall be the executive authority. So in Chinese, maybe it's easier to understand why the National People's Congress had taken this trouble. It says, 香港特別行政區政府是香港特別行政區行政機關. Now, the authorities, therefore, brings out the concept as a 機關, a department, a part of the larger concept of the SAR, right? And being the 行政機關, it is therefore the government. So that's the concept that we should get ourselves familiar. We should understand it in that manner. Then come the legislature. The legislature is actually a 立法機關. Now, 機關 is the concept of being part of a larger institution, which is SAR. Right? SAR itself, all these, of course, is conceptual. Right? And when you go to Article 66, it says that in the same sort of flow, same style to how Article 59 is expressed, it says the Legislative Council of the Hong Kong Administrative Region shall be the legislature of the region. And legislature here is spelled with the lowercase l. It's the legislature, right? So it is part of the same family, same institution. And within that, there are two parts. There are these two parts: executive authority, which is the government, and then legislature, which is the Legislative Council. Then comes to the judiciary. Judiciary, Article 80, it says the courts of the Hong Kong SAR at all levels shall be the judiciary of the region, exercising the judicial power of the region. So again, judiciary, it is the 司法机关, 司法机关. Right. And then the other two institutions that form the political structure of Hong Kong are respectively the district organizations, and the last is public servants. For this chapter, our focus will be on the chief executive, legislature, and the judiciary. We'll be using these abbreviations. The CE, it will be the chief executive. Legislative council will be LegCo, right? I mentioned this in very brief terms at the earlier lessons. People tend to think that it is important to classify governments into various categories or various types by reference to their relationship, constitutional relationship between or among the various institutions of government, parts of the government. The approach taken by the basic law drafters was that they did not, and they did not, as a matter of a considered approach, describe the system as either executive government or is a separation of power system. And yet, what it did was, in relation to each of the institutions within the government, their powers and functions are stipulated in specific terms, and then the relationship also are dealt with by way of specific provisions. Like Article 64, it tells you, it provides that the government is accountable to Legislative Council. What does it mean by accountable? In Chinese is 负责. 负责 could be translated as responsible too. But the English translators deliberately, and then mind you, the translators are official. This is an official translation. Prefer accountable, and accountability is a concept which is well understood in the UK Constitution, and there are a lot of case laws on that, on this meaning. And yet, in the Hong Kong Basic Law, whilst there's no definition to it to explain what is accountable, when we look at Article 64, you may agree with the following view, and the following view being that confirming that Hong Kong government, Hong Kong SAR government is accountable to the Legislative Council, and is but being spelled out in a particular, being spelled out in the manner how this is realized. When you go to 64, Article 64, please turn to that. Do you have it with you? Please turn to your basic law, Article 64. Can somebody read it for us? It's not. Simon, can you help us? Enable your microphone. Simon, can you read the provision for us? 64. You mean, Eli Man, you mean you can't hear me again? We had tested the system earlier. It seemed that it was working. It was working. Yes, I saw. Yes, thank you. Could Simon help us to read out what Xun has typed very kindly? Type it out for us.
Okay. Article
Yes.
64.
Yes, please, Simon.
The government of the Hong Kong Special Administrative Region must abide by the law and be accountable to the Legislative Council of the region. It shall implement laws passed by the Council and already in force. It shall present regular policy addresses to the Council. It shall answer questions raised by members of the Council, and it shall obtain approval from the Council for taxation and public expenditure. That's all.
Yeah, thank you so much, Simon. So this is how Article 64 set out the relationship between the government and the Legislative Council, and the word accountability had been a very commonly used word to describe the relationship between government and parliament in common law jurisdictions in which the system of government is very often categorized as a separation of power system. And yet, in the case of Hong Kong SAR, despite this reference to accountability, you will see later on that there have been various views expressed on whether the political structure in Hong Kong is one of separation of power, or is it one of executive-led government, or of some other names, some other forms. And recently, I'm talking about the last 3 months or so, the chief executive of Hong Kong had come out and saying in emphatic terms that Hong Kong there's no separation of power in Hong Kong, and this view was again also sanctioned or endorsed by the officials from the mainland, the central authorities officials. You will see from our menu, and here we have, and the menu obviously was put together well before this recent public debate. And we all along knew that this could be controversial, and that's why in our teaching of this subject, the basic law, we thought it is useful to have this as one of our main focuses of discussion. Article 64 has to be read very carefully. When you go to Article 64, what Simon did was he read out the entire provision. But what he common with any reading of provisions, you do not read, if you like, the punctuations. You don't, do you? You don't say, after a certain word and say comma and a semicolon or full stop. You don't. But on this particular provision, you will notice there's a very important punctuation used, which is a colon. The colon which appears after the first reference to Legislative Council of the region. It is following this colon that there are 4 aspects of matters that the government has to be accountable to LegCo. And these 4 are: 1, to implement laws passed by the Council; 2, present policy debate addresses; 3, answer questions raised by members of LegCo; and 4, obtain approval from Council for Taxation and Public Expenditure. So, one view taken is the word accountable to Legislative Council, the word accountable is limited by these 4 areas that are specified after the punctuation mark colon. So it is not the traditional or conventional relationship between governmental institutions in the separation of power system. Are you with me? Do you follow? Do you follow what I'm saying? Do you follow? And whilst the word accountable in English is familiar to most of us, and know roughly what the meaning is, both in law and in political science context. But in Chinese, it is actually the word used is 负责, is 负责. 负责, apart from accountable, could actually mean responsible. And in the context of describing a political system, what is accountable and what is responsible may bear different meanings. Even with Chinese, if you say that you are accountable to somebody, you can fairly say, "Oh, 向某某负责." But you can also have it translated as 問責. 問責. 問責 is the more commonly used translation for accountable. And what is 問責 is another concept which may be different depending on which jurisdiction are we using that particular word or applying that particular concept. So Article 64, please read that very carefully and register what I just said, and agree or disagree with government stance that there's no separation of power. Despite that, please, as a student, we should acknowledge that it can be argued both ways. It can be argued both ways. So on this slide, we say you have to decide for yourself, which is correct. Now, and of course, the decision has to be taken, can only be made, taken into account the views expressed by Central People's Government, the executive, and more importantly, the CE. So that's about the general points I want to make before we get into focus into the exact powers. Questions? Well, we say that you must decide which one you think is correct, and now that the chief executive has spoken, now that the central authorities have made it abundantly clear, then in terms of correctness, I think there's no other answer but what was then said by the central authorities, Bear in mind that this is a piece of law. This is a law made by NPC, by National People's Congress. So one in legal terms and practical terms will be bound by these meanings. But whether you are convinced that what has been said is the correct way of saying it could be debatable. That's how I will look at it, and you see, with the one of the approaches taken by CE was she said there's no I'm trying to do you read simplified Chinese? I hope you know you do. Instead of separation of power, it said that there is a distribution of power or allocation of power, right? How is that material? How is that important? It's arguable, but I think much more important is the practical relationship. The practical relationship there, we are actually we'll be looking at this more closely. You identify a lot of powers there, and many of which that CA is given are not subject to control of anybody, including the Legislative Council. He can do anything. He can do everything that he can do within the basic law without any other parties intervening. Except that he or she will have to account for whatever act that he does. And the Court of Final Appeal has also made it clear in some decisions that he can't, the CE cannot exercise judicial powers, so which seem to be quite, straightforward. As far as whether it's executive led, factually, you see that CE has got a lot more powers than other institutions within the political and the question is she subject to checks and balances? Can you answer that question? Is she subject to checks and balances? Yes, I think she is, and we have to identify these, and then don't forget the real question then is the effectiveness of these checks and balances. Are they really real ones, or are they just something put there as as a window dressing to show people that that's the way things are done in mainland China or in Hong Kong? When you read the speech made by Ji Pangfei in April 1990, the relationship between the executive authorities and the legislative council was described as one which is, in Chinese, is 互相制衡,互相配合. That is. So according to the speech made when in the National People's Congress, when the bill to the existing basic law was introduced, it was explained by the deputy chairman of the Basic Law Committee that the relationship should be one of 互相制衡,互相配合. So in English, that was translated as the following. I just wanted to get the proper translation of 互相制衡,互相配合. It certainly did not use the expression of checks and balance, but then it is mutual regulation and coordination, I think. But certainly it just hid itself among the many words that I'm reading. A text that I will come back to it later. I don't want to, so of course, I'm stuck here. I will find it. Yes, that and I think is the concept was this: is mutual regulation and coordination. That's how it's described. The relationship between the executive and the uh, legislature. The legislature. All right, and the next is focusing on what is government, executive-led government. Well, executive-led government is the preferred name for the system under the Hong Kong Basic Law. This is the mainland version, the mainland approach, and it emphasizes the power of the CE as head of Hong Kong. And this head is not a nominal head, but a head that possesses substantive powers. The chief executive should be more powerful than legislature or the courts. Why? Why is that so? Why do you think that is so? Why is it important from the mainland point of view that if they have, for them to prefer to have all the more important powers to be vested on the chief executive rather than the legislature or the legislatures? Why is that? Can CE dissolve? Let's go. Yes, the answer is yes. Yes, I think so. That probably is just common sense, isn't it? Just common sense. So my next question is, how powerful is the chief executive? you are asked to look at these articles more carefully. Articles 48, 49, 50, and 74. Okay? Now, let's look at these articles 48, 49, 50, and 74. '48 has a long list of 13 items of powers and functions. Remember, this is a what we call a lock and barrel approach. This is the reference to powers and functions. In the common law concept, fundamental concept is if you have a certain function given, then it is by implication or by interpretation that the CE must let me do that again. If you are given certain functions, then by implication, powers under common law, powers will have likewise been given for you to carry out those functions, and that's why they often come together, hand in hand. The first item of power and function is to lead the government of the region. To lead the government of the region. Well, is this a power or is this a function? A power or a function? A power? Well, let's look at the Chinese. To me, it's more. It says 领导. Why do you say it's a power? Okay. Power means accept or refuse. I don't. Power means accept or refuse. Can you explain again, Simon? Simon, can you try and explain? I think it's easier to say it than write it out at this point. Simon?
This is hello. Can you hear me?
Yes, I can hear you. Yes.
This is only my personal view. May not be some legal points.
No, it doesn't. No, it doesn't matter. We are looking at the meaning of the words here, right? I mean, there's no magic in the context of this particular word. No magic in the sense that it's not. We need not give it any meaning beyond what the words can mean. Now, the words are to 領導香港特別行政區政府 to lead the government of the region, and you said it's a power. It's a power. And my question is, why is it a power and not a function? And then you said power means accept or refuse. What?
Yes,
What means?
because according to the articles, the CE can accept to sign the bill or something by the law, and she also can refuse to sign the bills or laws. So I think this is some kind of power. But if she only can sign it, no rights, no choice to refuse the resolution from NECO. I think this is only the function.
Ah, good. I think I know what you mean. Is the word you wanted probably is discretion. Discretion.
Yes,
I think that's the word you were looking for. Discretion. I.e., in Chinese would be, how would you translate that? Discretion.
判斷
Pundun would be a judgment, a determination. Yeah. Did you see 酌情 is being typed out? 酌情. Yeah. Did you see that on the chat box? Wu Jiayi, she has got 酌情. 酌情, I think is the more commonly used translation. 酌取權. Uh, uh, yes, it's not that common, Philip, but sometimes we also have 裁量權. 裁量權. So that brings the meaning of the concept of either do it or not do it, either accept or not accepting it, right? This is what Simon means, power mean, right? But here, the focus is 領導. Now, to put your concept on 領導, that are you saying that the CE can decide to lead or can decide not to lead? Is that what you mean? And therefore, there's a power. Well, to be quite honest, 領導 is more descriptive of the status of the position, and itself is maybe too generic to classify it as kind of power. And indeed, that is a reflection more of the Chinese culture. We often would like to describe, somebody as the 領導, as the leader, and therefore they have the power to lead. But what does it mean by leading? Is very abstract. It itself is abstract. We think, and therefore this may very well be a notional function. Yes, that's right. Champak, 領導 means 以身作則. Well, it's the quality of a leader, maybe, but when you come to law, you will see actually this 以身作則 is reflected in the later provisions, such as item 2, which is responsible for the implementation of the law. And it then goes on to Article 47. Not goes on, but then when you look back to Article 47, 47 says that the CE must be a person of integrity dedicated to his or her duties. It doesn't say 以身作則, but it does, I think, use reference which bear that meaning. Is 47 is 必須廉潔奉公, 盡忠職守. It doesn't say 以身作則, but I think it's broad enough. Yeah. Hey, Michael, 塞紅包. Yes, as a joke, right? As a joke, and to be quite honest, I think this is a useful reference point where I have to repeat what I've been saying if I had not said it to you. The basic law. Uh, let's look back to history. This is for China to give effect to what it had elaborated and declared in the joint declarations, right? And this is, and therefore, this is not the type of law that we can't treat this as the normal type of law that the National People's Congress passes. Is one that honors, that is for honoring China's promise in the joint declaration, right? And among the promises, there's the basic policy of maintaining the original system, and also the way of life, and for 50 years, and no socialism, but only capitalism, and so on and so forth. There's a historical aspect to it, and and therefore you will see that some of this actually reflects and maintains the position uh, of the leader of the colonial Hong Kong. Now, the leader of the colonial Hong Kong in those days, in strict legal term, must be the monarch, the queen or the king, and his or her representative, which was the governor. The governor, and the governor, he certainly leads Hong Kong in the sense that he is the head of the civil service, head of is the president of the Legislative Council, president of chairman of the Executive Council. He appoints all the judges, and also he is the commander in chief of the British garrison, all the British soldiers under his command. So he was the supreme leader. That was the position of the governor. So 48, Article 48, Item 1. I should think is a difficult one to classify either power or function, right? So when we read 48 and 48, when it says powers and functions below, in fact, to lead the government, you can either say it can either be a function or a power. Right? That's how I would say what I would say. But then being or having such power or function to lead, then under the common law, that CE should at the same time be given some implied powers in order to perform this role as the leader. Some of the powers are already set out then in the provision that follows. Some, even without spelling out, may arguably be within her power, given to her by the basic law impliedly. Okay, so the next is we're still on 48, and it says to be responsible for the implementation of this law must be the basic law and other laws which, in accordance with this law, apply in the Hong Kong SAR. 3. To sign bills passed by LegCo and to promulgate laws. Also, to sign budgets passed by LegCo and report the budgets and final accounts to the CPG for the record. Now, this is what Simon referred to earlier about how to classify this as power or function. This is definitely a power. It says to sign bills. It actually it goes without saying that he can decide not to sign. He can decide not to sign. Right? and therefore it's a power. But then how that signing or non-signing power should be exercised, you will see that it is actually in Article 49, Article 49, where it says the CE may refuse to sign it if he is of the view that the bill is not compatible with the overall interest of the region, not compatible with the overall interest of the region. So that's the legal condition, a condition prescribed by law. If he did not see that it had any adverse effect on the region, then he cannot refuse to sign. Right? So that is how we should understand these powers. Number 4 is to decide on government policy and to issue executive orders. The issuing of executive orders, Chinese is 行政命令. At one stage, there have been worried amongst some that the chief executive is so powerful that he can actually make law, although they are not called ordinances, but they can be called executive orders, and they must be obeyed by the public at large. Then it will render legible without any real power to oversee the government. It was decided and accepted, though, by the courts and by Hong Kong government that this power of making the executive orders under 48(4) is not a legislative power. Is not the governor, I beg your pardon, CE cannot make law via this back door, i.e. he cannot say, oh, this is just an executive order that I make. That is an administrative act. That is an administrative act only. 48(5), that relates to the CE's power to nominate and report to the CPG for appointing principal officials. 主要官員. Number 6 is to appoint or remove judges of the courts at all levels in accordance with legal procedures. 7. Do you have a copy of the Basic Law with you? If you haven't yet, please download it or go to the website and you'll find it very easily. Anybody that needs time to find the Basic Law? All right, well done. Number 7 is to appoint and remove holders of public office in accordance with legal procedure. Number 8, to implement the directives issued by CPG in respect of the relevant matters provided for in this law, means in the Basic Law. 9 is to conduct on behalf of the government external affairs and other affairs as authorized by the central authorities. Number 10, to approve the introduction of motions regarding revenues or expenditures to the Legislative Council. Financial power under the Basic Law and also the constitutional model in UK and also adopted in many of its colonies and Commonwealth. The use of public funds by government obviously can only be for building hospital or building a road, that sort of public facilities. In order to get money, the government must raise tax, and therefore people of like Hong Kong people who can afford, who are more affordable, will be responsible for paying government money for the latter to perform public services. And this is taxation. And under the basic law, taxation has to be done by law and under the law. Now, it is a fundamental constitutional principle that government, therefore, in providing public service, can have a resort to the public funds, and these public funds are in the hands of one of the principal officials, and how and under what situation can a government department, lay their hands onto these funds? Well, by way of seeking LegCo's approval. This is where it is the same, very similar mechanism adopted in other common law jurisdictions, and it has been described as a system that manifests, that reflects the separation of power, because it is only for the executive to make the demand for money and for the legislature to vote on that demand in order to supply the money. The same is here in Hong Kong. Before 97 and also after 1997. But the only additional condition is whatever is done, it has to be done in accordance with the basic law. Thank you, Ken. Thank you, Mr. Gan Wei Yan. Yeah, I'll register that. Thank you. So, I was on this appointment of judges and appointment of public office holders, and I also brought up the respective role in the use of public fund. Come to 8, it is something maybe nowadays very controversial. It is to implement the directives issued by the CPG in respect of the relevant matters provided for in the basic law. CPG can give directives to the chief executive, no problem. I think even you may think that well, does it mean intermeddling? Does it mean central government intermeddling with with SAR affairs? Of course, we have to look at the substance of any of these directives. Some of this will be necessary because of the international relationship or international obligations that China had entered into. I remember, for example, one of the subject matter was the UN sanction, United Nations Security Council. They decide on a regular basis to impose sanction on certain countries. For this, Beijing the PRC government will have their own mechanism, and for Hong Kong, under one country two systems, these are matters within Hong Kong's high degree of autonomy. And sometimes you may have something which sort of fall in between, like the UN sanctions, where it is China's obligation to honor this agreement or give effect to UN Security Council resolutions. But at the same time, because Hong Kong, under the basic law, cannot deal with foreign affairs, and this is definitely foreign affairs, and that's why as a matter of practice, and now as a matter of Hong Kong ordinance, every time when the central government thought it necessary to impose sanction, the central government, represented by Chief Secretary, will write to the Chief Executive of Hong Kong, and she will take steps to give effect to that Safety Council resolution. Right? And that does not involve. That does not mean that the CE is acting without the sanction of LegCo, and therefore uh, may have contravened the basic law. But when we look at this again, you can just in the context of the questions that are raised, are these evidence of executive-led government? In a way, yes, because nobody else can do it but the executive, so executive-led. But on the other hand, you may think that this is just a matter of performing his or her own duty. There's no what is the word for it? No hierarchy among these government agencies. Once they're appointed, they become one of those, and once for whatever reason, their personal reason or not, they leave, not continue to work for government or work to help the CE, then nobody can change that. Nobody can change that. These now I can carry on. I have to carry on. I'm afraid. I was on 8, saying that actually CPG can, in some matters, have through the CE, can have their will or can have their decision implemented in Hong Kong. 9 is about conducting foreign affairs, external affairs as authorized by the central authorities. Number 10, to approve the introduction of motions regarding revenue and expenditure to LegCo. LegCo had decided that this power does not give the CE the power to do anything to affect the president of LegCo's decision about putting motions which have this effect of how this finances, how this money is used or is approved and used. And if any of these motions were introduced or were sought to be introduced by LegCo member, then it is outside the scope of 4810. 4810 should only cover motions having that effect intended to be moved by a government official. "12. To pardon persons convicted of criminal offence or commute death. Last, to handle petitions. 13, to handle petitions and complaints." So all 13 of these powers and functions. I don't know. Do you have any questions on them? Do you have any questions? I think I'll take a break now, 15 minutes, and we come back at 4:10 p.m. In the meantime, you can go through those powers and functions, and then if you have any questions, you can raise that when we come back. Is that all right? Thank you. Yeah, common to political structures of similar kind. that it is for the government to take the financial initiative, i.e. to make proposals for spending for incurring public expenditure, and for the legislature to approve those. And so it is logical that for the CE to have this power to approve introduction of motions regarding revenue and expenditure. However, the actual implementation of this, it was made very clear by the Legislative Council that this power should not include and does not include motions moved by Legislative Council members which may concern revenues and expenditure, because in any event, that the most they could do was would be to move such motions to urge government to undertake certain measures in the collection of revenue or in the in incurring public expenditure. Number 11, it is to decide in the light of security and vital public interest whether government officials or other personnel in charge of government affairs would testify or give evidence before the Legislative Council or its committees. This is a power, and this is also one that is used to counter, when we talk about checks and balance, to counter that the exercise of power to summon by the Legislative Council. We shall see later under Article 73, paragraph 10, the Legislative Council actually has the power to summon. Well, it can investigate and therefore it can summon. And this summoning power could be so great that it makes inroad into government administration and possibly forcing government to review things that which they didn't want to review. But this power is balanced by the chief executive power to refuse. Now, however, we have to read this provision very carefully in that this power can only be, there are some preconditions for exercising this power. It has to, CE can only refuse if it was in the light of security and vital public interest. Security and vital public interest. It is not or, it's and. All right. So it's a power limited. It's limited. And then the next we want to look at is the power to pardon, convict persons convicted of criminal offences or commute their sentences, their penalties. Again, a power commonly given to head of states, the Queen, or the governor in the colonial days. A power to pardon is different from what a court possesses. A court cannot pardon anybody. The court can only decide cases in accordance with law. And if there is evidence sufficient to convict a person of a crime and punishment duly given, then that decision will hold good unless it's reversed on appeal. Otherwise, if it was upheld on appeal as well, then nobody can change. Not even the CE can change. But CE has the power to pardon. The pardoning power, once exercised, does not have the effect of taking away, removing that criminal conviction record. Commutation is signified a reduction of sentence, reduction of imprisonment. Now that again is CE exercising mercy, obviously in the interest of in the public interest, and does not and cannot change what was decided by the judge as a member of the judiciary. The last function is to handle petitions and complaints. Handle petition is a general power. It doesn't say how these petitions and complaints have to be handled, nor does it say what will be the outcome of handling. Right? This is a function that obviously will be subject to the reasonable exercise of powers in order to carry out that function. I'm not going to go through with you others yet, because they will come back, i.e. 49, 50, and 74. We'll come back. I don't want to read so much to you, but you read it, just you go and read them. And 49 is about returning a bill for reconsideration. 50 is about dissolving LegCo. 74 is about LegCo members wanting to introduce a bill for that to be enacted into law. If the bill concerns government policies, then such member will have to obtain consent from the chief executive, and has to be given consent given in writing. So it's a way to regulate LegCo members' power. Which are the most important powers? Now, we've gone through powers together. I wouldn't sort of ask you to do that now. I think in the course of introducing these powers, I have indicated their relative importance. But look at the last question: are these evidence of executive-led government? Are these executive-led government? Therefore, what do you think? Somebody? Yes. Okay. Now, I think certainly the question can be answered in the positive, because it is asking you whether these are evidence. Right? Surely, because they relate to the power of the executive, of the chief executive, these must be evidence. Right? But whether at the end of the day, in order to draw a conclusion on whether the system or the structure created by the basic law is therefore can therefore be described as executive-led, I think probably it's still a little bit too early. All right. You may not agree, because you may think that, well, by looking at 48, especially 49, 50, and 74, it's already quite clear this political structure must be described as executive-led. But that can, I think, is a bit rash, not prudent enough, because we should first of all define what is executive-led. If executive-led means, just like Jia Yi said, is a lot more power given, then it is. But if you say you think executive-led have other meanings, such as for some means that it is for the executive to take initiative in the lawmaking powers, in lawmaking, in controlling public finance, then it is quite different. We will have to examine other provisions as a whole before you can come to a conclusion. Again, powers. This is really looking at 48 more closely, and of course they are already there, and we know by now that these powers are contained in Article 48, contained in part of 48 and 74, and also 50. Got it? Who is more powerful? The chief executive of Hong Kong or other elected presidents? Ma Ngok is a professor in political science, so this does not involve examining the degree of popularity of various presidents or governments, but only looking at the facts. What are the results? I don't know whether it's clear or not. Ma Ngok, she had used executive power as a basis, one of the criteria for determining whether the CE has greater power than other places. I'm not going to take you through this, but looking at Hong Kong is 8 legislative power score, 15 non-legislative power score. So, CE is a lone person. In fact, for CE, when you talk about loneliness, once the person is elected as CE, under the Chief Executive Election Ordinance, the CE, if he belongs to any political party, he must resign from that political party when she takes up the CE's office. What is Executive Council? Executive Council is an advisory body. In the colonial days, there was similar body bearing the same English name. For Chinese, pre-97, Executive Council was described as 立法行政局, but now it is 行政會議. And we can see a photograph of the current Executive Council. You probably know everybody here already, know their names. Their relationship and with the CE and their powers and functions are contained in Articles 54 to 56. It forms a very small part of the executive branch, not many, you can count the numbers, so less than 20. Although in law there is no provision on the maximum number. And for our purpose, we do not expect or require you to know anything in depth about the Executive Council, only to know that there is this body. which assists the chief executive. Separation of powers. Now, when you go to the Judiciary website, and if you use separation of power as a search term, you will find this being referred to in many judgments. And but government's position is that Hong Kong doesn't have separation of power. But let's look at it. Why the court's been mentioning it, and why are scholars think that there is such a relationship? First of all, the straightforward way of describing the Hong Kong system is under the Basic Law, government is divided. Government organs, there are three government organs, quite distinct. They're called the executive. One is the authority, the other is legislative, the third is judiciary. The initial purpose of checks and balance is to provide as the name suggests, check, i.e. to stop any one branch from abusing their powers. And chief executive has important powers, and of course it was the idea of the Basic Law drafters that he or his exercise of power should be restricted. Whilst on this point, sometimes some people may ask that in light of the position being taken by the chief executive and mainland China on the existence or otherwise of separation of powers in Hong Kong, are we going to create another constitutional crisis? Either because this would lead to an interpretation of the Basic Law, or this might become a basis for somebody to take the government to court. This is something I cannot guess. I don't have more information than anybody else. But one thing we can be sure is when you look at the judgments, local judgments, the lower courts tend to be less concerned, and maybe it's because they very often when they write their judgment, they write it in a shorthand form. Shorthand form in the sense that when they make, in order to saying that the relative relationship with the between the government and the legislature, they will make reference to checks and balance or separation of powers to describe the relationship as a shorthand. Which has led to what is being, some had complained that the confusion was caused. One of the causes of confusion was the way that the judges have been writing their judgment, and conscientiously or otherwise, even seem to be adopting the government of three powers into Hong Kong Basic Law. So what we say, I think more accurately, is that there is a division of labor, and because it's a legal environment, so we are talking about a division of powers, and also ultimately, if we were talking about legislature, we'll make sure that or make sure not to forget what the what the Legislative Council as a whole can do. And this is the last bullet point here about the restriction by checks and balance by legislature and the courts. This is how they function. The courts checks two levels. One is case specific. Of course, the court can do whatever they thought is achieving justice by making orders against the parties. But there may be a lot many more who are non-parties for various reasons, and the courts should, and I think they have, tried their best to make reference to the people in those positions. Are we okay there? Just talking about the courts, we can see that in the case of Leung Go-hong, number 1, here 2014, there was a reference to a concept of constitutional separation. The Court of Final Appeal says this doctrine is a common law doctrine, which in the case of Hong Kong is reinforced by the constitutional separation of powers provided for by basic law. Sections 1 and 2 of Chapter 4, which is the political structure, set out the powers and functions of executive agencies, while Sections 3 and 4 make similar provisions for the legislature and the judiciary. Article 2 of the Basic Law also recognizes the separation of powers. So it was this judgment was among the quite many which seem to suggest that the separation of power concept is a recognized concept. It's not mentioned anywhere in the preamble, and I think this must fall within the implementation side of one country, two systems, and will not be affected. Therefore, the respective roles and functions of the three organs of power will not be affected. So that's that. What about other places? Most countries have some form of separation of power, and best known example is about US, which has some similarities or instrument. No separation of power in China. Why? Because I had said to you that China adopts a centralized system, and all government agencies, including all government agencies, no separation of power in China because NPC is the supreme organ of power. It does delegate, but if the situation should require, the NPC can recoup all this power back. And China is suspicious of separation of power in Hong Kong. I've been saying no. In a way, it's understandable. And through the former director of the liaison office, Zhang Xiaoming, and he now is one of the deputy director of the Hong Kong MAO, which is Hong Kong and Macau Affairs Office back in Beijing. And it was as back as 2015, and as recent as just about 2-3 months ago, he had said similar things. And he said it should be clear that Hong Kong has not been implementing the political system characterized by the separation of power never before nor after its return to China. But Hong Kong exercises an executive-led political structure with the chief executive at the core, where there are both checks and balances of power and cooperation between them, between the legislative and executive branches, as well as independent judiciary. Yes? So that's Zhang Xiaomi, the way he described Hong Kong's political structure as executive-led and imposing checks and balances. What does separation of power mean, and what do they mean? First of all, we got these three agencies. There's no dispute, and they act on their own. Do not interfere. It's not subject to interference. Only exception is where existing checks and balance has stopped by power or other two branches. And we are talking about imminent breaches, not only if you suspecting the hospital authority is not, it has been abusing the power, and it's up to you to prove that. And then let's look at the CE. Example of separation of power. One is the case in 2006. CE cannot make power because that is LegCo's power. CE cannot decide prison against that because that is court's power. 3. Courts will not usually interfere in the internal workings of LegCo. Okay. The 2014 case is about the it's the Legislative Council oath cases. Are you aware of that? Legislative Council oath cases? Heard about them? Heard about Leung Tin Kei, and heard about Yao Xiulai. You read about them? The other case or rather another obvious checks and balance. I mentioned to you about the executive or the chief's power to, for example, examine the balances, examine the accounts. And as a result, the discussion with the financial secretary and decide to write up a budget for introduction. The budget meaning parts of which include new measures to recoup finances or about cancelling about using public money, and that has to be approved by LegCo, which we already mentioned that. And also in examining the budget, indeed the finance in examining the budget, the finance committee of LegCo may also summon people before it. So this slide shows you in more detailed form the checks and balance, and and to emphasize that the respective role is entirely different, entirely different. Zheng Gasun and Lei Fengying case. Heard about this case? Do you know Zheng Gasun? Yes, and as a developer, Zheng Gasun's company had invested in developing a project on Kowloon East, Hong Kong East, and it was alleged that the development was, some aspect of it was was not in accordance with with certain rules, and it was said that even that was the case, with that, with such a disclosure, the company, the developer, still thought it was good investment, and there was an allegation that a former civil servant called Mr. Leung had given the company some special treatment, and therefore could have been acting, his act could have been against public interest, and constitute a misconduct in public office. So with all that, LegCo decided to perform its own investigation, and there was reluctance on Mr. Leung's part and on the part of his investors to go before the Legislative Council to answer questions. However, the more they wanted to refuse, to deny coming, the lawyers representing them had decided to take LegCo to court, alleging that they had been acting beyond what is allowed by the Basic Law. The case went to the court as a kind of subject matter, as a case of judicial review. The court finally decided against the application, and it was only after that the Senate committee carries on. In the course of judgment, the Court of Appeal indicated that any allegation of misconduct, or any allegation from Mr. Zheng Gasun, would have been made up at that stage, at the late stage, and therefore the other party, and that provided the incentive not to allow the former government servant to go before the committee to give evidence. These form part of the allegations, basis or allegation in the court. The court looked at all the facts and the Basic Law, and took the opportunity to explain the relationship to explain the nature of the power of electrical in summoning witnesses, and to what extent and who are those people who would be bound by this electrical committee. It is a select committee, by the way. Yeah. The court held against Mr. Zheng and decided that the common law doctrine of non-intermeddling, i.e., the courts will not sanction any conduct interfering with the performance of functions of electrical. And if the matter concerned about some internal workings of electrical, and even if government came forward and said it is the government who wanted to put things right, i.e. the electrical possibly had not been doing it properly within the scope of the power given by electrical. So those are the arguments, but the Court of Appeal took the common law line, saying that that's fundamentally it's so clear that the common law, what we call non-intervention principle, should apply, and i.e. The courts do not probe into internal workings of the electrical, especially if it concerns financial matters and is a matter for the council itself. So this is Chen Carson against Li Fengying. Most important check and balance. Well, in the UK, that will be in the impeachment. But of course, there are others too. I think in Taiwan, they've got other method of putting a vote to all the members and decide about the future of a certain individual. But impeachment is more about the Legislative Council, in the case of basic law, Legislative Council taking action against the Chief Executive on the specified grounds, and at the end, it has to be fact-based, i.e. whatever said has to be checked, has to be investigated, to making sure that whatever's written out now form the basis of the attack. The power to under Article 73(9), electrical can make allegation against the chief executive, alleging that he had committed some serious crime, or that he had excuse me, dereliction of duty. He had dereliction of duty, and therefore should be impeached. Such a motion can only be passed if there are 2/3 of the members present voting. The question, there was one question asked about and if such impeachment motion is passed in electrical, which requires 2/3, the only thing that the SAR government can do is to make a report of that decision to Central Committee, and that's it. What Central Government Committee and what GCG does with that is a matter for the Central People's Government. Of course, many I'd argue that there's no room for other arrangements. If a CPG receives such information, then CPG must give effect to it, i.e. Must dismiss the governor. Right? yet to be seen how NPC Senate Committee will deal with such kind of impeachment motions if they were passed in Hong Kong. Okay, I propose to take a little break because I'm going to move on to looking at a new topic, which is law making. I suggest you, Oh, 然後 that was one of the allegations. Yes, shall we continue? Thank you. Lawmaking. The Article 66 created the legislature, which is Legislative Council, and its powers and functions are set out in 10 items, and the most important one about lawmaking is item 1, which says Hong Kong Legislature has the power to enact, amend, or repeal laws in accordance with the provisions of this law and legal procedures. Legal procedures was considered by the court in a case, and it was accepted that that refers to at least the rules of procedures made by legislature on its own. There are different types of laws. Of course, in our legal system, court judgments are a type of laws in the sense that the ratio decidendi have under the doctrine of precedence has the effect of law. Otherwise, and then that we sometimes call them unwritten law. On the other hand, written law are laws made by the legislature in accordance with the, in our case, procedures set out and recognized by the basic law. there are two tiers of legislation. One is from bottom is called subsidiary or secondary legislation, and this is law made by the executive or some other bodies which are which not is even not part of the government. For example, in our case, uh, 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 we have the Ocean Park, for example, or MTRC. These two bodies, respectively, they can make bylaws to regulate uh, 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 one visitors to the ocean park or passengers or NTR their conduct when using their facilities. That is governed by the secondary legislation bylaws authorized by law. And the next is the most important type of law is the statutory law, is called primary legislation. In Hong Kong, these are called ordinances. Yeah. And under the separation of powers, only LegCo can make these laws, except some Chinese national law under Article 18, 2, and 4. Now, we had looked at that previously, and in the context of the relationship between this central authorities and Hong Kong SAR in relation and in the context of one country, two systems. 18, 2, and 4 involve the listing of national law on into Annex 3, and either by way of promulgation or by way of local enactment, those national law can become Hong Kong law. And these include, for example, the national anthem law, which is by way of local enactment, and now there's an ordinance on national anthem. There is one other law which was listed in Annex 3, but then by way of promulgation has become part of Hong Kong law, and that is the national security law. So, but coming back to the context of separation of power, it is only the Legislative Council that can make law, right? CE cannot make law, despite the fact that CE has the power to make executive orders. These executive orders are not law, right? This is what we had looked at in Article 48. There was a case which was decided in 2006, and it was made very clear that CE cannot make law. Now, in the case about the law enforcement covert surveillance order, in that case, because under Article 35 of the Basic Law, private communication is protected unless except interference was authorized by law. And the CE thought that CE knew about this requirement and had made an order which is called the Law Enforcement Covert Surveillance Order. Pardon, not make this law, but rely on previous internal instructions, and thought they could be considered as sufficient legal basis for tapping, for interference, for tapping, that sort of thing. The court decided otherwise, and was not and made clear that CE can't do it. The only way that can be done is to take a bill to LegCo, a bill, which means a proposed law to LegCo for enactment, and that was eventually done. Eventually, it was done, but it took time. So the court saw the need, or the practical need of time, and therefore had as a very exceptional measure agreed to delay the commencement of the court order, right? So that was a case that decided or made clear that CE does not have the power to make law. Excuse me. Another example, another example is on this very controversial Article 23 bill. It was very controversial because government in 2003 attempted to honor to perform its obligation under Article 23 of the Basic Law to make laws on national security, creating offenses of subversion, secession, theft of state secret, and so on. It attracted a lot of opposition or protests. That's beside the point. But the making of that law eventually did not succeed, did not pass Legislative Council, and ever since then, despite the concern raised by central authorities that government had not been able to honor carry out its duty since 1997, but they couldn't take over Hong Kong's legislature's role to enact the law. But of course, at the end, what it did was, by way of a decision made by National People's Congress, authorizing the Standing Committee to enact national security law for protecting the national security in Hong Kong SAR. So that has become what we call the NSL nowadays, and have that law taking effect in Hong Kong through Annex 3 of the Basic Law and promulgation. Dissolving LegCo. Well, we talked about this earlier. CE does have a quite is very, very powerful. In the colonial days, a governor can dissolve LegCo, but now this power to dissolve is subject to certain conditions. First of all, it cannot be done arbitrarily. It has to be done in accordance with the Basic Law. And the Basic Law set out the situations under which such power may be exercised. It is when LegCo refuses to pass the budget or any other important bill. What is the budget, one may ask? Well, the budget, in the practical terms, in the Hong Kong legal system, it is the annual appropriation bill. Hong Kong's public finance system is by way of annual budgeting, and each year the government has to go to the Legislative Council to seek approval of funding for the various government services that government performs each year, and this is by way of enacting the appropriation bill. Let me type it out. Appropriation bill. Oh. And that is in Cantonese is 撥款條例草案啊，撥款條例草案啊。I'm afraid my computer somehow the Chinese input has been in default is simplified Chinese. I hope you will be able to read that. Yeah, and so appropriation bill each year around about February, early March, there will be such an introduction, and when the Financial Secretary introduced that bill, he will make he will make a speech, and that speech is called a budget speech. contains the financial positions and the economy generally, and proposed expenditure and revenue. For revenue, that has to be sanctioned by So, in the context of dissolving LegCo, we are talking about LegCo not agreeing to pass the appropriation bill. That has not happened so far. And it also provides that if LegCo refuse to pass any other important bill, well, you may ask, the logical question at this point is, what is an important bill? What is an important bill? Huh? Well, appropriation bill will no doubt be that it is an important bill. But what is important bill? How important is a bill an important bill? Yes, but there is no. The NSL doesn't need. There wasn't a bill for LegCo to pass. That's what I was saying. It was a real. It was an central authorities took the other route to have that made. I mean, initially, Article 23 bill did not get passed, so no Article 23 law, but Article 18 of the Basic Law does provide a route for central authorities to have such or indeed similar law to take effect in Hong Kong directly. What is an important bill? Well, the Basic Law has not provided a definition, and the Legislative Council and government have been in discussion for many years since '97 on what that means, and they have not come up with any sort of decisive, clear answer. But I think it was basically agreed that when it happens, then we will all know what that is. In other places, like for example in France, where there is a similar system, it would be for the president to I think it's the prime minister to identify, to say beforehand that this is an important bill within the constitution. If Parliament does not pass it, it will mean a vote of no passage of a vote of no confidence, and they will have to dissolve Parliament and to have a re-election. Now, there's no system as such in Hong Kong yet, and but what it signifies is that this can only be a political judgment, a political decision. We cannot rely on any objective factors in order to identify what is and what is not an important bill. And it's also unclear whether the court may be involved in such in the operation of this part of Article 50 of the Basic Law. It's still unclear, right? we have said that no CE has ever taken this route yet, this Article 50 route, and we have also asked you to look at Article 52.3 and trying to find out maybe it's relevant to decide in deciding why it did not happen. Why is it important? Do you have 52.3 there? Do you have Article 52 bracket 3? When you read it, you have to read from the start, Article 52. Article 52 says this. So Article 52.3 actually, yeah, Simon, you got it right, and is CE must resign, right? So you can see this is a quid pro quo situation. It is a situation where if it's a double-edged sword situation. If the CEA decided to take this route and did dissolve LegCo, he is exposing himself to a situation under which he must resign. He must resign. So this is what you may describe this as a kind of check and balance relationship, or not relationship, but check and balance system, right? A check and balance, and you can from this you can go back to what has started this discussion, i.e., whether there is a separation of power system in Hong Kong. Well, it's for you to argue whether there is or there isn't, but such system is objectively present. It's already there. So does it really matter, right? Whether there's separation of power or not? But it is quite clearly there is a kind of check and balance there. You got it? You got this one? Good question. Then comes to the next slide. Let's look at the next slide. We have been saying that only LegCo can make law, but look at what CE's power has, what sort of power the CE has, and also what kind of voting system that the basic law has provided. So the starting point is, yes, okay, only can LegCo make law, but look at this. Under Article 74, if a member wishes to introduce a bill, they can't introduce a bill that relates to public expenditure, operation of the government, or the political structure. And if the bill relates to other government policies, then they must obtain the written consent of the CE before such a bill can be introduced. LegCo, although it's a lawmaking body, it can't make any law if there's no bill. You see what I mean? So, in a way, the CE is controlling what kind of law that LegCo can make. Either bills that are introduced by the government, or bills introduced by members which had already received the written consent of the CE. So that lawmaking power doesn't, in actual fact, is not as big or as great as what one initially thought. Is subject to CE's control. Secondly, when you look at the voting procedure, government bills passed are introduced by government under Annex 2 of the Basic Law is passed if the simple majority of members agrees to pass. So if there were 50 members present, then you need 26 members saying agree the bill will be passed. Simple majority of those members present. However, if the bill is introduced by a member, then the bill is only considered passed if there's simple majority of members of each of the two groups of members present. Which are the two groups of members? Well, LegCo's members are comprised of two groups. One are 35 of them elected from geographical constituencies. The other group, 35 from functional constituencies. The banking services, the medical services, the legal group, the engineers, the chambers of commerce, the labor unions, and so on. And of course, 5 of them are from the district council election, from the district council. So, for a member to have the members' bill passed is much more difficult than a government bill. So, to that extent, LegCo's power and therefore members' power to initiate a bill for it to be passed into law is highly regulated, restricted by the CE. All right. In more detail are the following 2 slides. These are actually I had already introduced. We call this members' bill called private members' bills. Private members' bills. This is just a technical term. There's no particular magic there. Only because this expression is used to distinguish them from government bills. And each session, very few private members' bills are passed in Hong Kong. What are those? They are normally related to either churches, schools, and other private organizations. LegCo is more powerful. Jia Yi, yes and no, isn't it? Now, having learned this, and then I'll show you the next slide on voting. About the voting, you see that 2 voting system, and the one that requires the passage of 2 groups is called split voting system. And you can see that, like here, where 35 present, each side, everybody, a full house, everyone was there. And look at that, you got 28 28 members who had agreed, and 37 disagree total. And you will see that this one, because functional constituency is negatived, then that bill cannot be passed. All right. So I think you can form your own views whether government is, or whether LegCo member actually is more powerful, or is it CE who is more powerful. The split voting system helps government, of course. Functional constituencies in reality is usually dominated by government supporters, and so it seems that government always stand a very high chance. The proposals not supported by government normally will be defeated. Agree? CE has even greater power there, another power, which I mentioned earlier, that CE will have to sign the bill unless it's not compatible with the overall interests of Hong Kong. And however, if LegCo pass the same bill again by 2/3 majority, then CE can dissolve bill. However, it's unlikely to happen because CE may be forced to resign, right? So both under 52.2 and sometimes under 52.3 with the important bills. All right. So you can see this comparison of the comparison of powers is almost like one. It's almost like a match. It's a boxing match. When you deliver a blow, there's another blow in return. So at the end, who is more powerful is difficult to tell exactly. But the system is such that there's always the counter side, something to counter the other. Okay. What I wanted to take you through with the remaining part is the elections. I think I will reserve this for our next meeting. On the elections of the CE and the elections of LegCo members, and we'll talk a little bit more about the qualification of members, or indeed the disqualification of them. The recent decision, of course, 4 LegCo members have been disqualified to continue serving on the 5th term LegCo during the extended term for some reasons, as decided by the Standing Committee of the National People's Congress. Are there any questions here, please? I do not know, I'm afraid, because it is a matter of administration, and I do not know. I will ask. I don't quite understand your question, Michael. Michael, what is it behind your question, please? I have already set the assignment, and then I can't even remember what. Let me see. Let me see. Oh, right. Yep. I think I can do it this way. Yeah. The assignment question is not difficult. We haven't reached that, but I will paste it here. Shall I? Would you like to see it here? No. Now. Oh. Yeah. Okay. This is a question that we which we normally set for the final exam. This is an exam, a question on the protection of human rights in Hong Kong, and it involves an understanding of Article 39 of the Hong Kong Basic Law, and how it operates, and how the courts in Hong Kong, especially the Court of Final Appeal, have developed tests to uh, uh, um, to identify or provide tests for the courts to determine if any restrictions imposed either by law or any restrictions imposed by executive decisions on the exercise of fundamental human rights are or are not incompatible with Article 39 and therefore contravene the basic law. We have a chapter, the last chapter, and this is mainly chapter 8, human rights, and so in terms of helping you, if you are interested, you can start reading that, and since we have a break of a week or so, so you can for those who like to start early, you can try think about this question. The only snag is since it has not been released to you in SOL 2.0, so this cannot be formal. Do we have other questions? I think it's 2,000 words. I think I can't remember. I think usually it's 2,000. I think there's a word limit there. I think it's 2,000. Oh, do I prefer? Well, no. It's this question. I thought it got 2 question marks, so it's one question, but divide. But you can deal with that in 2 parts. I can't remember the word limit for it. I think it was 2,000. Not more than 2,000. Yeah, that's right. There's a word limit, so you can, if you can Comfortably deal with it in less than 2,000, all the better. Yep, can confirm. Do not exceed 2,000. Do not exceed 2,000. That's what I said, Michael. But I had entered a caution because it's not released in SOAP 2.0, so it cannot be taken as the formal question. There might be changes that I can't, that may be beyond me. 2 means the second paragraph? What do you mean? Oh yes, that's right. Is around that, around, because a question of this nature, is really a matter of personal style. It's really a matter of personal style. So by and large, 1,000 something will be just fine. All right, shall we call it a day or call it a week? And I shall be seeing you next year. Oh no, December 29th. December 29th, I will be seeing you, right? Tuesday. And we will finish off the election part and we'll start with Chapter 6, Judiciary part. Shall we? Great. Merry Christmas to you all, and have a great time despite the pandemic. Yes, I still got some urgent work to deal with in the meantime, and good. Thank you so much.